Is that? You don't have any problem associating names with accounts when you go to bill people, which you do every month. I seem to recall getting a bill from you monthly. You had no problem associating my name with my number when you wanted money from me. But when it came to protecting the basic rights of your consumers, your subscribers, your customers, you couldn't be bothered?
No, Senator, I would not say that.
A senator, a telecom giant, and a paper trail they hoped nobody would ever read aloud in public. What you're about to watch is not a debate about policy. It's a company getting caught, doing exactly what they told you they'd never do. Watch carefully.
Thank you very much, Madam Chair. Thanks to the witnesses for being here. Mr. McAtee, let me just start with you. I just want to try to drill down and get clear on what happened here. When you got a subpoena from Jack Smith for Senator Cruz's records, you pushed back on this. How did you do that? I mean, how did you know it was Senator Cruz whose records were being requested?
In that case, Senator, it was fairly obvious. The subscriber name was Ted Cruz for Senate, so we put it together.
Yeah. Huh. So you thought to actually look at the number and match it up and maybe see if there might be a legal problem here. You asked a few questions. Is that fair to say?
That's correct.
And
Senator.
what happened next?
What happened next was we did some research, as you would expect any legal department to do. As I mentioned earlier, we consulted with outside experts. We talked among ourselves. And we determined that even though the subpoena was obligatory, that we were required to respond to it, we can always ask a question. And so we asked the question, and we sent an email from my department that I read into the record earlier, asking for special counsel's views on the potential constitutional implications under Article 1.
Did this subpoena include a non-disclosure order with it?
It did, Senator.
But that didn't stop you from conducting a basic inquiry?
No, it did not.
Okay. Well, I'm glad you did the inquiry because, as it turns out, the non-disclosure order was totally illegal. As we've covered now exhaustively in this hearing and in others, statutes in place on the books in 2020 require notification to sitting members of Congress if their information is subpoenaed in any way, not to mention the contract that the Sergeant-at-Arms has with all three of the major telecoms. So I'm glad you did your job. My question for you is, Mr. Miller, why didn't you do any of this?
Senator, at that time, and I recognize we should have had a better process here, but at that time, we did not train our subpoena analysts to do a searching inquiry into the subscriber associated with a particular
What does that
telephone
mean?
number.
What does that mean? You just didn't bother to try and associate the phone number with any name?
Senator, we respect the privacy of our customers, and we did not want...
Apparently not, because you turned over every piece of information from every senator sitting on this dais who got any illegal subpoena. You turned it over with no process at all. So let's skip that part. Just get to the part where you tell me why you didn't do anything that Mr. McAtee did.
Senator, the process we have in place now would largely...
I'm not interested in that. I'm interested in why you didn't do any of the basic investigation. Ask a question, you get a subpoena for all of these numbers, and your testimony is you just handed over the documents, you didn't do anything? Is that what happened?
Three reasons, Senator. So first, when we receive a subpoena, we do not know the nature of the investigation or the sensitivities involved. Second, as I mentioned, we train our subpoena analysts to respect the confidentiality and the privacy of our
So you don't try to
subscribers.
match up, you don't look and match up the numbers. You're telling me you don't try to associate a number with a name. You don't do that.
No, Senator. We do now for members of Congress, but that was not the procedure at the time.
Really? Because you testified to Senator Durbin not long ago that you disclosed all of the names to this committee of all of the people who are associated with the numbers, including mine. So clearly you had the ability to do it, you just didn't do it. Is that correct?
We had the ability to do it. Yes,
But you
Senator.
didn't do it.
We thought we had good reasons for that, Senator.
Why is that? You don't have any problem associating names with accounts when you go to bill people, which you do every month. I seem to recall getting a bill from you monthly. You had no problem associating my name with my number when you wanted money from me. But when it came to protecting the basic rights of your consumers, your subscribers, your customers, you couldn't be bothered?
No, Senator, I would not say that.
I would. I think I just did.
I would too.
That word, contract, is doing enormous work right now, because this is no longer about bureaucratic failure or outdated training protocols. This is about a billion-dollar company that collected government money, signed a legal agreement to protect the people paying into that system, and then quietly handed sensitive data to federal prosecutors without a single phone call to warn anyone. And the deflection you just heard, "I don't agree that we violated the contract," is precisely the kind of corporate non-answer that survives in boardrooms but collapses the moment a senator reads the contract language out loud. The real question nobody in mainstream coverage is asking: if they did this to senators, what do you think they're doing with yours? Drop your answer below. Are telecom companies legally obligated to protect you, or do you just assume they will?
Senator,
Why didn't you follow the contract that you have with the United States government? You've got a contract worth millions of dollars with the United States government, which obligates you to inform the Sergeant at Arms if you get any requests for processor information from a senator or any number associated with that contract. That contract was in place, and that language was in place when these subpoena requests came through, and you didn't do any of it. Why is that?
Senator, I don't agree that we
You don't agree with what?
That we violated the contract.
Really?
with the
The
Senate.
contract says that you are obliged to inform the Senate when any records are demanded. And I'm quoting here from a letter not from Senator Graham, not from a Republican. It's from Senator Ron Wyden, who sent a dear colleague letter to every member of the United States Senate, May 21st, 2025, notifying us that these contract terms were being regularly violated by your company, among others. So why didn't you follow the contract that you were making millions of dollars on? Why didn't you do that?
Senator, I get your frustration with this issue, but the contract.
No, I just want the truth. I'm frustrated because we get the runaround constantly. We've gotten it all day from you. So why didn't you follow the contract?
Senator, the contract covers a definition of Senate data. At this time, we did not interpret the contract to apply to the
To
kind
phone
of
lines?
records, to the kind of records that Verizon generates, as opposed to records
Oh,
that
for
the
heaven's
Senate
sake.
generates.
This is just absurd. And I'll just say this, Madam Chair. We're talking here about members of Congress. If you are a normal person, if you are a working person out there, just think of the fact that these guys, with one exception, Mr. McAtee's company, AT&T, all the other guys just handed over this data. They couldn't do it fast enough. They rushed to do it. They can find you when they want to bill you. They can find you in a heartbeat. When it comes time to protect your data, they're nowhere to be found. It is absolutely a disgrace. And the fact that you testified earlier that you get hundreds of thousands of requests for personal information every year is chilling, because what all your customers should know is you just turn it over willy-nilly. I would expect better from you, from all of you, frankly. I think what you've done here is outrageous, and I think the implications for the privacy of the American people are absolutely unbelievable. Thank you, Mr. McAtee, for protecting your customers. I wish these other guys would do the same. I tell you what, everybody ought to go to AT&T, because Verizon and whoever you are, T-Mobile.
When Senator
you guys
Hawley
are
looked at
terrible.
Verizon's representative and said, "I think I just did," he wasn't grandstanding. He was closing a loop that had been building for the entire exchange. And if you watched it carefully, you already know what actually happened in that room. A company that processes hundreds of thousands of data requests every year just admitted, under oath, that it never once stopped to ask who it was handing that data about. Let that land. Not who, not a senator, not a staffer, not a name on a contract worth millions of dollars. Nobody checked. Nobody asked. They just complied. Now here is what that actually means beneath the surface. The framing of this hearing has been almost entirely about congressional privilege, about the specific rights of sitting senators under Article 1 of the Constitution. And that framing is correct as far as it goes. The subpoenas were illegal. The non-disclosure orders were illegal. The telecom companies had a statutory obligation and a contractual obligation to notify the Senate, and they did neither. That part of the story is settled. But here is what nobody is asking. If the legal apparatus of the United States government, a special counsel operating with the full weight of federal authority, can send a subpoena to a major telecom, attach a gag order, and receive a senator's complete call records without a single flag being raised internally, what exactly is the protection for anyone who is not a senator? Think about what this means if you are sitting on the other side of this. You are not a senator. You do not have the speech or debate clause. You do not have a legal team. You do not have a subcommittee chairperson willing to spend an entire hearing demanding answers on your behalf. You have a phone contract, and as of this testimony, that contract means exactly what Verizon decided it meant on the day the request came in. Why now? That is the question. This hearing is happening in 2025. The subpoenas were issued in 2020. That is a 5-year gap between the violation and the public accounting. In that window, careers moved forward, investigations concluded, and the people whose records were taken had no idea it had happened until someone else decided to tell them. That gap is not a bureaucratic lag. That gap is the system working exactly as designed for the people running it. Supporters of strong federal law enforcement will argue that prosecutors need tools, that subpoenas exist for a reason, and that a special counsel operating under a court-supervised mandate should not be second-guessed by a telecom's legal department. That argument has merit on its face. Nobody wants corporations deciding which federal investigations are legitimate. But critics, and this is where the argument gets genuinely serious, will point out that the non-disclosure order attached to these subpoenas was not a neutral legal instrument. It was a mechanism that prevented the targets from ever knowing their information had been taken. That is not oversight. That is covert data collection on sitting members of a co-equal branch of government. The word for that, in any other context, would be surveillance. And both camps are missing something entirely. The most chilling testimony in this entire exchange was not about senators. It was when Hawley noted, almost in passing, that Verizon processes hundreds of thousands of personal data requests every year. Not hundreds, not thousands, hundreds of thousands. And if the standard operating procedure, confirmed under oath today, is to comply without cross-referencing names, without checking for constitutional implications, without notifying anyone, then every single one of those requests is being handled the same way. Your data, your number, your records. The telecom companies built the infrastructure of modern communication. They also built the infrastructure of modern surveillance. The same system that lets you call your family lets the government pull your call history. And as of today's testimony, the only thing standing between your records and a subpoena is whether the company receiving that subpoena decides to ask a question. AT&T asked. Verizon did not. One company read the room, the other read the subpoena, stamped it, and sent the data before the ink was dry. If this is the kind of analysis you are not finding anywhere else, you already know what to do. There is a historical parallel worth sitting with here. In the mid-2000s, following the revelations about warrantless wiretapping programs, there was a public moment of reckoning about telecom cooperation with federal surveillance requests. Congress eventually passed retroactive immunity for those companies. The controversy faded. The infrastructure remained. What changed was the expectation. Americans largely accepted that the companies holding their data would cooperate with government requests and tell them nothing. What this hearing suggests is that the expectation never really changed. Only the target did. When it was ordinary Americans, it was national security. When it was senators, suddenly it became outrage. Short sentences land harder here. The data was taken, the law was broken, nobody was stopped, and the company made money on both ends, charging the senators monthly for the service, then handing over the records for free. That is not a failure of process. That is a failure of principle. The final line of this hearing, everybody ought to go to AT&T because Verizon and T-Mobile, you guys are terrible, will get clipped and shared and laughed at as a moment. But strip away the theater, and what Hawley actually said is something more serious. The only reason any of us know about this is because one company chose to do what all of them were legally required to do. The story is not finished. The contract violations are documented. The names are on the record. What happens next, whether this becomes legislation, litigation, or a footnote, depends entirely on whether enough people decide this matters. And that question is still open. Thanks for watching. If this kind of analysis is what you come here for, subscribe so you never miss an upload. Share this with someone who needs to see it, and drop your thoughts in the comments, because this conversation is far from over.